Thank you very much, Mr. Chair, and thank you very much for all the questions. I understand that adopting enforced disappearance as an autonomous offense is a hot topic, but nevertheless, as Ms. Janina raised, we answer with sincerity, and that the way we understand it, the Cambodian delegation, is that this is a bridging exercise. You're experts of the convention, we're experts of our laws, as you mentioned, and this is our way to have a dialogue and bridge our understanding between each other. So I'll start with the autonomous offense, and then I also apologize to Ms. Lockbiller. I will go to your questions next. On the autonomous offense topic, we take note. We take note of your comments, and we understand. Our position right now is that the crimes that are enshrined in our criminal code adequately fulfill the obligation. We understand that many other countries have this position as well. Nevertheless, as mentioned in the beginning, this is a bridging exercise, and so we do look forward to your detailed comments regarding the adoption of enforced disappearance as an autonomous offense, and we will consider. But as we mentioned, our position is that we believe we fully comply with Article 2 with the various criminal code crimes within various provisions within our criminal code. Regarding the 4 cases that Ms. Lockbiller raised, I'll start with Mr. Munsom and Mr. Osman Karaka, as these cases are closed, but nevertheless we don't consider them as enforced disappearance cases. Why? Because with regard to Mr. Karaka, I'll be brief, was that there was constant communication with the Turkish embassy, and that they knew the whereabouts of their citizens. And with regard to Mr. Munsom, what we have is that Mr. Munsom was illegally logging. Authorities came to visit him. He fled. He was found in Phnom Penh working, and now he's back in Brevia. And so there was no arrest made with Mr. Munsom, and it is not considered as a case of enforced disappearance. Regarding with Mr. Kum Sapat and as well as Mr. Wan Chen Lam, within our criminal code, cases that are undergoing investigations are bound by confidentialities. So beyond what the government has shared with regard to these 2 cases, we can only say that these 2 cases are under investigations. They are currently with the courts, and the investigating judges are still conducting investigations in trying to search for these individuals. We do not consider them as enforced disappearance cases because we do not consider that we haven't found any evidence that agents of the state were involved in any of these cases at the moment, at the time being. I will now move on to the remaining questions as well as the follow-up questions. I will quickly touch upon the Royal Gendarmerie. Ms. Janina raised concerns with regard to the military police. Apologies, perhaps I wasn't clear, but the Royal Gendarmerie, yes, is a military police, but under the Criminal Code Procedure Code, they have the power to conduct investigations as the same as the National Police. But this is to be distinguished from military courts. Military courts only handle issues of military cases. So when the military police or the Royal Gendarmerie conducts investigations and find cases that are related to enforced disappearance, this appears before civil courts or criminal courts. But their power is that they can investigate just like the National Police. Moving on with respect to Article 111 and the discretion regarding the discretion of the judicial police when there is a crime. For this, I will pass the floor to my colleague, but I will note that just like in other jurisdictions, when there are reasonable grounds, the police or the judicial police, they will conduct investigations, but they have the discretion before sending that case to the prosecutor. This is a general principle of law. And so, if they believe that there are no reasonable grounds for there to be a crime, of course, they won't send this case further up. Nevertheless, within our criminal procedure code, a complainant does have the right to appeal this to the prosecutor or the prosecutor general of the appeals court, and their right to complain is also further enshrined within the Constitution. And so, even if the criminal procedure code, in a worst-case scenario, is not helpful, under the Constitution, they can then go to the courts themselves to resolve this issue. But I will then pass the floor to Excellency Gideon.
Thank you, His Excellency and Delegate. I think in regarding Article 11 of the Criminal Procedure Code, stating that when learning about an act that can be an act of felony or misdemeanor, judicial police officer may conduct a preliminary investigation at their own discretion. I mean, when they heard about even a complaint or maybe it's a kind of criminal act, they just only investigate their own. But in terms of, for example, if they proceed with arrest or search, this should be follow the criminal procedure in terms of how to search whatever, and then also inform to the prosecutor to inform that now we have a clue of criminal act, so need to have some authorization or consent from the court to pursue further. And also, for example, if they do not, but at the request of prosecutor themselves request the police, the judicial police officer to conduct it on his behalf and to send all the report what they're finding to the prosecutor, in order that prosecutor will be proceed the next step. I mean, maybe okay if we find out there is a criminal act, they can issue an interrogatory submission, a regulatory authority to the investigation judge, whatever, as I highlight in the process how to investigation. So in this case, and I would like to highlight as well, our head of the brigade has already mentioned, has only highlighted and mentioned. For example, if the prosecutor do not prosecute one person, that if there is some clue and there is an offense, normally we have even Minister of Justice also have some power to also to request for investigation, and also if they don't want to arrest that person, the perpetrator, they call also issue an order. And also the general prosecutor of the appeal court also have such kind of authority. I do not remember the word in French word about the order that the Minister of Justice can order to arrest when there is some flagrant element of crime happen. Yeah. So this is just only to highlight a bit on this. Thank you.
Thank you, Excellency. I keep looking at the time, so I will try to proceed as concisely as possible with the remaining questions. Let me now move on to the possibility to suspend from duty those who infringe, and civil servants or public officials who infringe or break the law in cases of enforced disappearance. Cambodian law recognizes this. We have a law on public servants that allows for the possibility of disciplinary sanctions when laws are broken or when they act in a certain way that is contrary to their professional conduct. Regarding the National Human Rights Institution draft law, and the question from Ms. Janina was whether there's any indication on the specific times. We cannot speak for the Office of Council of Ministers and the Council of Jurors of when they will finish their review, but all we can say at this point is that they are in the process of review. And I know for a fact that the Council of Jurors is also reviewing many other laws being submitted by other ministries and institutions. To give you, again, a little bit of context of Cambodia. Cambodia, now that we have achieved peace, stability, and development, we are in the process of reform. And so many ministries are focused on having their laws, new laws reviewed on that is relevant to their sector. Regarding the declaration on Article 31, Article 32, and who decides on this, simple answer is the government decides. And so that would mean consultations with all relevant stakeholders, including the Ministry of Foreign Affairs. But of course, the institution that will communicate such declaration will be the Ministry of Foreign Affairs, who handles foreign affairs and international cooperation matters. On again, on the explicit provision of derogation, of non-derogation, our position, Cambodia's position, is that this is already guaranteed by the Constitution, and the fact that there is no explicit provision allowing for the derogation means that the government cannot commit certain acts, such acts, acts related to enforced disappearances, even in state of emergencies. Because, for example, within the law of state of emergency, if in the state of emergency is declared, Article 4 lists the certain activities that the government can take, including, for example, the restriction of movement. But there is nothing that explicitly says that the government can conduct, and nor will the government conduct, such activities during times of state of emergency or even peace times. Yes, please.
Thank you, Hisley. To have the floor, I want to add more on this. Normally, when we, according to the law on in case of emergency declare, we need to follow all the constitution, the process. I mean, the government need to report to the National Assembly in order to control and also to keep update what is the process of conduct of the measure. This is to guarantee that the liberty and freedom of people shall not be touched and shall be violated the Constitution. So here's a kind of process that control supervised by the National Assembly. And in such a case, also there's some joint meeting between the Senate, and also the National Assembly to have some word on the measure. And then if they adopt that or need to stop, they will stop it. This is a kind of guarantee of the freedom, and also there is no any violation of the liberty of the people in terms of implementation of the Constitution and also the law on management. And I think we refer to this article also as well, and just in addition, Article 10 of that law on management of nation in the state of emergency. I think we can highlight it. It's mentioned that relevant civil servant who exercise authority that different from the objective of the law and the cause of the physical damage to the property of other must be held responsibility in accordance with the law of the Kingdom of Cambodia. So there is no excuse, there is no derogation. Whatever you do, you commit a crime or act in this, you need to be responsible. So just edit. Thank you.
Thank you. And there is also a question with regard to aggravating and mitigating circumstances, and perhaps our explanations were unclear, but I'd like to pass the floor to Excellency Kurin again. But just before I do, yes, the judges do have discretion, and for example, with Article 96 on it states that in imposing penalties, one of the distinguished delegates asked what factors there were. In imposing penalties, the court shall take into account the seriousness and circumstances of the offense, the character of the accused, his or her psychological state, means, expenses, motives, as well as behavior after the offense, especially towards the victims. So we provide a certain level of discretion to the judges when deciding the sentence.
I think I would like to provide a concrete example of one infraction, one offense. For example, torture and acts of cruelty. In the criminal code of Cambodian, when committed again, it should be punishable by imprisonment from 7 to 15 years. But also in each category, sometimes we have an aggravating circumstances regarding the status of the victim. So I can point it out Article 211 in terms of the status of the victim. For example, the punishment shall be imprisonment from 10 to 20 years if it is committed against a person who is particularly vulnerable by the reason of his or her ages. Again, a pregnant woman whose pregnancy is obvious or known to the perpetrator. This is a kind of an example that in each category of crime, we have also the aggravating circumstance that define just an example what I have highlighted. So, but the other we have also in the, it depends. So in this article, we have a lot of circumstance that the perpetrator will be punished seriously in accordance with the acts. Thank you.
Thank you. Moving on to what I have next with regard to responsibility of superiors, and that allow me to elaborate on, to make our answers clear, that it would cover not only active instructions, but also other acts by superior and in ensuring accountability. So we have Article 28 of the Criminal Code that talks about an instigator. So for instigator, an instigator of felony or misdemeanor shall be of any person that gives instructions or provokes the commission of a felony or misdemeanor by means of a gift, promise, threat. So this captures its indirect connection, that not only are instructions enshrined here, but also the provocation of the commission of a felony or misdemeanor. And with regard to Article 29, an accomplice shall also be any person who knowingly, by aiding or abetting, facilitates an attempt to commit a felony or misdemeanor. So, superiors who knowingly aid, abet, or facilitate a crime shall also be held liable. Article 32 of the Criminal Code states that a person shall not be criminally responsible if he or she performs an act prescribed or authorized by law. But a person shall not be criminally responsible if he or she performs an act ordered by a lawful authority unless the act was manifestly unlawful. So a subordinate who defies their superior when the act was unlawful is free from liability. And Excellency, yes, you wanted to add.
Thank you, His Excellency, Head of Delegates. I would like just only to highlight this also in terms of aggravation circumstance when the status of the perpetrator. So I can highlight Article 213 regarding the offense. The punishment will be from 10 to 20 years if it is committed by a public officer in the performance of his or her duty in connection with. So this also is a kind of responsibility when they perform their duty, and there is aggravating circumstances also. Thank you.
We did not highlight this, but allow me the opportunity to do so. Are also Articles 528 and 529 of the Criminal Code speaks about the omission to file a complaint against a felony or misdemeanor by a public official. So if a public official has knowledge of a felony or misdemeanor through the exercise of his or her function and omits to inform a judicial authority or other competent authorities, they shall also be punished, imprisoned from 1 to 3 years. And any person who, having knowledge of a felony, the consequences of which they still able to prevent, omits to inform the judicial authority or other competent authorities, shall be punishable by imprisonment from 1 month to 1 year. And so with these additional provisions, our Cambodia's position is that, including the aforementioned provisions as well, is that our obligation in recognizing the responsibility of superiors is fulfilled. Okay, I'd like to continue with the next question regarding minimum and maximum sentences. The request was to provide an example. So yes, for crimes against humanity, the maximum sentence is life imprisonment. But for other crimes like torture, rape, or in cases related to enforced disappearance, such as unlawful confinement, different maximum sentences shall apply to the different categorization or different type of offense. All right, I'd like to move on to Ms. Quintana's question. I will skip the question on autonomous offense, as I already mentioned. But with regard to the Supreme Council of the Judiciary, the question was, what is the process of the appointment of, what is the process of the appointment of members of the Supreme Council of the Judiciary, as well as the appointment of judges and prosecutors? For this, I pass the floor to Excellency Gideon.
So, once again, as I have just highlighted of the composition and also what is the law governing the appointment, suspend, put a disciplinary penalty or fine to the judge. This is covered by the statutes of the law on organization and functioning of the court, and also the statute of the magistrate mentioned on this. So normally, when the appointment is based on the performance of the judge and the prosecutor, normally if we have the judge have been complained for their impartiality, or there is some, if they do not implement correctly the law, normally the complainant can file a kind of, first it's an administrative intervention to the Ministry of Justice in order to find out, and also they can file a complaint to the Supreme Council of Magistracy to conduct investigation in order to find whether there is any misbehavior of the judge or prosecutor. This lead to is a kind of disciplinary sanction. So based on disciplinary sanction, normally in Cambodian law, we do not publish, but actually we do have a lot of lists of disciplinary sanction for the judge and prosecutor. We have it, but we do not declare that, okay, this judge A have been sanctioned for the disciplinary sanction. But we do have a list of sanction when the Supreme Council of Magistracy, because they have one council of disciplinary sanction to conduct an investigation based on the complaint from the complainant or their representative. They can go directly to the Secretariat of the Supreme Council of Magistracy or go to the Ministry of Justice. But normally, Ministry of Justice, now I can highlight that in terms of reform, implementation of reform for the new government, we focus a lot of file speedy up process. We have a campaign for the speedy up process, and also irregularity of the process. We have also set up a committee in charge to supervise this. And there is some such kind of irregularity, or there is some complaint for disciplinary sanction. We will submit to the Supreme Council of Magistracy to decide on this, but we do have that. And if they have, as I highlight already, we have few cases that the prosecutor or judge have been tried due to the corruption case. We have few. I used to highlight when I highlight about the composition of Supreme Council of Magistracy. So this is what we would like to share and I'll add up on this point. Thank you.
Thank you very much, Excellency. Regarding Mr. Diop's question of Cambodia's obligation within Article 3, yes, Cambodia does investigate, as mentioned, with regard to any crimes, including crimes that are related to enforced disappearances. And throughout the cases that we have so far, there were regarding statistical data that is possessed by the Ministry of Justice. There are no cases that are related to enforced disappearances. And this statistical system is maintained by the Ministry of Justice, as mentioned by Excellency. And perhaps, Excellency, you can elaborate a little bit more on that, our statistical information system.
Thank you. For the statistical data and normally we have an central authority to collect all the information from the court. Normally the court will send all the judgment to the Ministry of Statutory Court, and also to categorize the kind of offense based on their category. So we have this kind of, we could not say we have, how to say, comprehensive, but we have a data for the data case management, and also we collect all the judgment or sentence from the court of first instance or the Supreme Court when it is final, in order we categorize according to their kind of infraction. And normally we also publish and share with the authority in order to show how many cases that related to which crime, and also it's a kind of share in order to prevent also as well, in terms of implementation and enforcement of the law and regulation. Thank you.
Thank you. Moving on to the next question that I have here is with respect to investigation. On investigation, can investigation start without a complaint? And yes, the police does have the discretion. And I do want to note that was not noted before that, especially in crimes that are flagrant, they have a duty to report to the prosecutor in order to investigate. And on this note, I want to tie this with Ms. Quintana's question regarding Cambodia's process. We are a civil law system, and yes, the process is an inquisitorial one. And so with respect to your question regarding the role for prosecutors and what happens if there is dismissal, and can it be appealed, and their relationship with the investigating judge, I give the floor to my colleague from the Ministry of Justice.
So when the prosecutor issue an interactive submission for investigation, the judge shall be investigated, comprehensively, seriously. So they need to find all the evidence, and also in terms of discharge and charge, in order to be a conclusion at the end is a closing order. So in this process, there has involvement of also the victim, and involvement of the witnesses, involvement of the representative of the victim, or representative, the lawyer, attorney at law from the relevant. And at this stage, they can have interview all the child person, the witness, the victim, and also the lawyer. With the presence of their respective lawyer, and also they can conduct an investigation by using a regulatory commission. As a kind of asking the cooperation with relevant authority to provide evidence. I mean, for example, if we to find the evidence is in the charge of the police, we will cooperate with the police or judicial police in order to conduct an investigation. So I think this we in the investigation process we also respect the confidentiality. Thank you for the time. So.
Thank you, Excellency. I see that our time's up, so I'd like to pass the floor to Mr. Chair.
Merci.
Thank you. Thank you very much for all of these replies to this first part of the dialogue, which I think has been extremely enlightening and interesting. So I thank you and your colleagues in the delegation for that. My thanks also go to my colleagues, also to our conference services and interpreters. I'd also like to acknowledge the presence of those who have joined us online via the webcast. That brings us to the end of proceedings for today. We look forward to meeting with you again tomorrow morning between 10 and 1 p.m. Thank you very much. A very good evening to one and all.